If everyone is okay with that, I will just make a recording of this video and we will just post it in our YouTube channel. So whoever wasn't able to watch this lecture will be able to then rewatch it. All right, if it's fine with you, we can just start right now, Ivan.
Yeah, I think we have 65 people have the critical mass. Sorry, you wanted to say something. Yeah.
Yep. Once again, welcome to everyone. Welcome, Ivan. Thank you for accepting our offer. Even though you are very busy during the week and during the season, we really appreciate your willingness to help our society to improve and increase the knowledge about ADR and international commercial arbitration. And I hope our collaboration with the students from different countries will be very fruitful. And floor is yours.
Thank you, Fusen. So hi, everyone. It's very nice to see you here and to give, I understand, the first lecture of this course of lectures of Kazakhstan Arbitration Summer School. So it's very good to see you here. Just to introduce myself, I am an English lawyer and associate of White & Case in London office of White & Case. I've also done secondment to Dubai office in 2018, 2019, but I've mostly worked in arbitration in London for the last 6 years. So yeah, I've worked with international commercial and investment arbitration in different regions. I've done some disputes in Latin America, in the Middle East, in Eastern Europe. I've done a bit of Central Asian work, but not that much so far, but it will be interesting to work with the region as well. So just at the beginning, some set of rules. Please don't turn your microphones on. If you have any questions whatsoever, please write them in the chat. I'll try to answer all of them in the end of the session. There'll also be some interactive exercises in the end of the session. Also, please submit your replies in the chat. Yeah, so let's start. So international arbitration is a very big topic. You can definitely not fit everything in 2 hours. So I decided to confine it to 3 main topics. So the basic principles of international commercial arbitration, the legal framework, which you need to know for international commercial arbitration, and arbitration clauses, sort of the foundation for arbitration disputes. Starting with the first topics, the basics of international commercial arbitration. So what is arbitration? Basically, arbitration is pretty much as old as the world. It's been used since time immemorial. I think we can see first examples of arbitration in the ancient world. I'm sure it was available in Central Asia also for years and years before that. I think the current foundations of the system come from medieval times when different guilds and commercial institutions had different ways of resolving their disputes outside of the country's national authorities and the king's courts, and they're able to resolve them between themselves by appointing a third party to resolve their disputes. Arbitration is a private and binding method for resolving of disputes. You need to remember that it's a creature of contract. It's based on the consent of the parties. This consent can be given either before you start the dispute, sign an arbitration clause in the contract, or after the dispute has arisen, if both sides know that they have a difficulty, a controversy between them, and they decide to submit it to a particular arbitration institution or to a third party, which would resolve it. It's supported by a complex system of national laws, international treaties, and soft law sources. So, for example, you would have a national arbitration law or civil code, which establishes the national framework for arbitration. But if you work with it, you also need to know the international conventions which apply to it. Most importantly, the New York Convention of 1958. But also there are various other different conventions which apply to different parts of the world. Arabic countries and Middle East have different conventions for arbitration. Latin American countries have different conventions. So you need to be aware of this. And we'll talk about the legal sources a bit further. The disputes would be resolved by an international arbitration tribunal. It typically have 3 members, but sometimes you can have 1 member. In very rare cases, you may have 5 members or 7 members, but I would say 1 or 3 is the golden standard. And they derive their power from the parties' agreement to arbitrate in the arbitration clause, or sort of after the dispute has arisen. At the end of this process, tribunal would issue a decision, which is usually called an award, and which can be enforced if it's a New York Convention award in 170 countries or even more than that around the world, obviously subject to local procedural rules, local arbitration laws, and so on. You can have several awards in the same case. Tribunal can issue interim decisions in form of decision, order, or sometimes even interim award. They will not be final, but they will be subject to the final award of the tribunal when the case concludes. So the key question to remember is that the arbitration is based on consent. Arbitrators cannot do anything unless there is a consent of parties to do it, which is why it's so important to draft arbitration clauses in a very consistent and broad manner to enable the arbitral tribunal to basically resolve the dispute in the most efficient manner possible. And that's why arbitration agreements, as I will be discussing at the end of the session, they should be drafted very carefully. They should cover existing disputes, future disputes, and various other issues. But basically, I've recently reviewed several arbitration agreements for different types of contracts. And yeah, there are so many levels of complexities of this under different laws of different countries. And yes, you need to, if you have different international code, you need to involve foreign lawyers and so on. So it's a very complex process, and it's very important to establish consent at the outset and to ensure that it covers all potential dispute which can arise out of this contractual arrangement. Moving on to the next slide. So arbitration against litigation. Arbitration is an alternative dispute resolution system, which is sort of an alternative to your normal state courts like the Kazakhstan state courts. They have something in common. They're both final and binding. And they're a third party in arbitration, the arbitration tribunal in a court, in a litigation system, a national court, for example, again, national courts of Kazakhstan resolve the dispute. But the distinction is that litigation is established by the state, typically even in constitution, you would have established the court system. It's permanent, it's mandatory for all local companies and certain foreign companies, depending on the rules of private international law. It's public. So the documents in most of countries will be publicly available in some database. It's state organized. Arbitration is temporary. The tribunal is constituted for each case. It's contractual, based on contract, private, and it's state supported because states would usually have arbitration laws which support use of arbitration. In fact, states benefit from arbitration a lot because it reduces the pressure on the court system. When the more cases go to arbitration, basically there is less of a backlog in the court system and they can resolve disputes prompter. Key issues to remember is that arbitration awards are based on consent, and tribunal generally, in most of cases, cannot make orders to the third parties. So if somebody has not signed the arbitration agreement, tribunal will generally not be able to make an order to them, order them to do something, which sometimes complicates things, and which is why we have multi-level complex consolidation clauses. As Usan would remember from the Vismut this year, the issues of consolidation and joinder can be very complex in different sets of rules. There is also no court rule. Typically, you would have an arbitration hearing, but nowadays you would often have it online. But if you have a physical hearing, you would have it in a hotel or in a sort of a private run institution like the ICC's Hearing Center. In London, there is ICDR, which is International Dispute Resolution Center, which offers these services. It's very fun. There are some very expensive sort of VIP service providers where you can have a private entrance where nobody can see who enters the building for better confidentiality, and so on. So depending on your client's budget, you can actually have a sort of very VIP arbitration experience, or it can be very a normal hotel meeting room. It all depends on the will of the parties. It's usually confidential. I think you'll have an investment arbitration section later where they'll tell you where it's not confidential, but most of commercial decisions are confidential. Some institutions like ICC publish excerpts, sort of extracts from the arbitration awards. They redact the name of the parties, the details of the case, but they preserve some of the legal reasoning. Again, for the purpose of, if you participate in the Vismut, it would be a very good source of knowledge and precedents. There are also different procedural and evidential rules to be used in arbitration. Some of them you would find in state laws. Again, some state laws prescribe rules for arbitration. It's also, if you use arbitration institution, you would have the rules of, say, ICC, International Commercial Court in Paris, or you would have rules on evidence, like IBA rules on evidence. I'll cover this a bit further in the lecture. So arbitration is very international in nature. I've never had a case where both parties were from England or from the same country. You would often have parties from different nationalities. It would rarely be, unless it's a very domestic Kazakh dispute resolved in a domestic arbitration court, you would probably have parties with different nationalities. Arbitration would usually be situated in a neutral country. So the most popular seats are London, Geneva in Switzerland, Paris, sometimes New York for some types of disputes. The countries which are perceived to be neutral, I think at the moment, there is also a trend for some Asian and Middle Eastern institutions rising. So Dubai, the arbitration centers in Dubai and Abu Dhabi are trying sort of to gain more disputes in the Middle East. You can see Kuala Lumpur and particularly Singapore Arbitration Center gathering a lot of disputes as well. And even in my work, it's very common to have international arbitrations which don't have any English parties between them resolved in London or in other parts of the world. So commercial arbitration is based on contractual disputes. So as you can see on the right side of the slide, you would often have construction or infrastructure project disputes. So if somebody is building a power plant in Kazakhstan and there are foreign financing companies involved, foreign construction companies involved, you would often have an arbitration agreement. Same with energy, oil and gas and power. Then you have different distribution supply agreements. There are a lot of disputes in M&A transaction, particularly when the party makes certain guarantees about the financials of the company the other side is buying, and some of them turn wrong. You would often have an arbitration dispute. A recent trend is to have arbitration in finance. Until recently, large banks and private equity and financial institutions were a bit reserved about using arbitration, but now you can see more and more financial disputes submitted as well. And I think I won't speak much about investment arbitration because you have a dedicated lecture later. There are two main types of arbitration, which is institutional arbitration and ad hoc arbitration. So in institutional, there is a set of international organizations, such as the London Court of International Arbitration or the International Court of Arbitration in Paris, which have existed for hundreds of years and have resolved disputes for all this time and can help you with a dispute, but they may be quite pricey and invasive. So if you want to have a very flexible dispute, you may opt for ad hoc arbitration. Ad hoc arbitration, you don't have any institution to administer. Basically, the parties are free to decide which rules to apply, how to choose the tribunal. If they haven't done this, then the tribunal would be free to determine a lot of these issues. If you have an entirely ad hoc arbitration clause, which is not recommended generally because there is too much space for things to go wrong, the tribunal would be able to determine anything. And if the parties cannot agree on the tribunal, in some cases, you can go to courts at the seat of the arbitration, and I'll explain what the seat is, and get help from national courts. But typically, even if you want to have an ad hoc arbitration, so you don't want any institution or international sort of, they're often called courts, to administer the dispute, you would still choose some rules like UNCITRAL arbitration rules, which would give some framework for your dispute. So why would you choose an arbitration? The key advantage is enforceability of the award. There is a New York Convention, as I mentioned before, which is 1958 document, which essentially allows an award made in one New York Convention state, of which Kazakhstan and all of Central Asian countries are parties. I think Turkmenistan was the last to join, but now all Central Asian countries are parties to this convention. So if an award is made in Kazakhstan, you would be able to take it to English courts or courts of New York or courts in Brazil and enforce it there. Obviously, it's not as simple. There would be some national rules to comply, national rules to check. But in theory, you can, if you have an award, you can enforce it in 170 countries, if the other side obviously have assets there. Then it's viewed as neutral and gives equality to the parties. Often, why parties often use arbitration? Because if you are an oil company, say from the United States, investing in Kazakhstan, you may be you don't know how Kazakh court system works. You don't know Kazakh laws. It often may make sense to go to a neutral jurisdiction where you've used it before, arbitration. And it's equal to both parties because it's neutral. It's usually, so if you have a party from America and a party from Kazakhstan, you would often choose Paris or London or Geneva as a dispute seat because it's neutral to both parties and there'll be at equal standing there. Then you're also free to choose the tribunal. While it's not recommended to specify in the arbitration clause that the tribunal has certain qualifications, if you have a construction dispute, you may choose an arbitrator who was working in construction industry before as an expert or as an engineer who would actually know what the dispute is about. Same about oil industry or any other industry. So we are very free to choose arbitrator who is much more qualified than a state judge would be to resolve this particular dispute and would know the relevant industry. It's also very flexible. Basically, everything is up for grabs, subject to certain rules in the national arbitration laws of the seat. You can choose pretty much any element. You can choose the language of the arbitration. You can choose how you present evidence. You can choose any aspect of the arbitration and make it very flexible for your particular dispute. It's confidential, which is why a lot of companies like it. There are thousands of arbitration decisions made every year, probably tens of thousands or even hundreds of thousands if you include domestic cases. But we know only about probably several % of them, which are actually published and go to courts because one of the sides refuses to comply with the decision. Yes, then expertise, which kind of crosses with the choice of the tribunal. You can choose people who actually know the industry you work with to resolve the dispute, which is very helpful in some very technical disputes. And the other advantage is finality, because as you may know, and I'm sure it's like this in Kazakhstan, if you win a case in the court of the first instance, the other side can appeal, and then you may have a cassation procedure, and then you may yet go to the constitutional courts. And the cases may be footballed between different stages of the court system for years. For a while, there was a so-called example of Italian torpedoes, for example, because at some point, Italian court system was very backlogged. And there was a case where one party submits a dispute in Italy against the other side, and it'll take about 10 years for Italian courts to decide that they don't have jurisdiction to hear the case. And for all this time, you have ongoing court proceedings in Italy, and other courts may be reluctant to take the dispute. So arbitration resolves this, because generally arbitration decisions are not subject to appeal. They may be set aside, so if the tribunal violated some fundamental rules of local judicial system, and these rules are established in the New York Convention and in local courts, which sort of specify them in more detail, it may be set aside at the place of the seat of arbitration, but in general, it cannot be appealed with very limited exceptions. What are the disadvantages of arbitration? There is no precedent value. For example, big advantage of English court system is that you have precedent. So while again, it's not that straightforward, if you have a similar factual scenario, you may see how the court would decide. In arbitration, there is no precedent system. One tribunal is not bound by decisions of the other tribunal. Obviously, if you choose English law, the tribunal would still most likely follow the precedents set up by English courts, but they are not bound by decisions of other tribunal. Probably they don't even know about them because they are confidential. So there is a bit of inconsistency in the arbitration system, especially it applies to investment arbitration, which again, you would hear from a different speaker later. But there is a lot of talk there that there needs to be more precedent value, because you can see different tribunals coming to very different decisions in exactly similar set of facts. Then there is usually no summary judgment procedure. I think current arbitration rules are trying to create it. So basically, what summary judgment procedure? When a dispute is very simple and obvious, or the other side doesn't show in the dispute, and it's very simple and obvious. In many countries, like in England, there is a summary court procedure where the court makes decision very fast. So you can get it within a couple of months if you're lucky. While in arbitration, generally the tribunal needs to hear the case. I think many arbitration rules now have dismissal procedure where they don't have jurisdiction, where there is no arbitration agreement. They can throw the case away so that the parties don't spend a lot of money proving this. But it's still quite rare, and I cannot see it being applied very often. Then the quality of decision makers is another concern. Obviously, you would want to choose a very experienced arbitrator, but sometimes you may have a bad apple in the system, and you need to be very careful about the members of tribunals you choose. It can be harder to use it in multiple contract dispute. For example, if you have a big construction project in Kazakhstan, you would have a lot of parties. You would have the employer, sort of the party which wants to build something. Then you have the contractor or many contractors and subcontractors, different companies building different aspects of the project. You will have the engineer who plans everything, and so on. And if you have such a complex arrangement, it may be hard to adjust arbitration clause for this. You really need to hire some very experienced law firm to plan all the contractual arrangements so that you can have all the same parties in the same dispute. Then tribunal don't have coercive powers, same as domestic courts. Domestic court, basically, they can start, in some cases, for example, in England, if you don't comply with the court decision, there is a so-called contempt of court, where it's up to 2 years in prison for not complying with an order of an English court. Arbitration tribunals obviously cannot send you to prison. They can only draw adverse inferences. So they can only reflect this in costs. For example, in the end, they decide that one party was disruptive, didn't listen to the tribunal, and it needs to pay more of the legal costs of both parties, or most of the costs of the tribunal. But they cannot order a party to comply with something. And this may be a problem. And in some cases, it may make more sense to go to the litigation because of that. And another reason is cost of the arbitration tribunals. Generally, state courts are quite cheap, while arbitration would typically involve very specialized law firms. The fees of institutions can be quite high. In ICC, you need to pay to the ICC, you need to pay to the arbitrators. And the hearings in arbitration cases often take 2 to 3 years. Now there are some expedited procedure for faster resolution of more simple and smaller disputes, but still, it can be cheaper to resolve the case in the court system. Another key principle to have in mind is arbitrability. So in general, the New York Convention has a presumption that if the parties have chosen something to be submitted to arbitration, have signed an arbitration agreement, it should be the court, if it gets the case, should refer the case to arbitration and should not look into the case. However, not all cases can be resolved in arbitration. For example, arguably, you cannot submit tax disputes to arbitration. You cannot submit criminal disputes to arbitration. Intellectual property is also problematic because you often need to register a patent, and the private tribunal may not have the power to do this. Often bankruptcy cases also cannot be submitted there. In the United States, some time ago, there was a big discussion whether antitrust issues can be submitted to arbitration as well. I think in some post-Soviet countries for a while, there was an opinion that corporate disputes where ownership of the shares is being decided could not be submitted to arbitration. And there were a couple of very dangerous cases. Generally, you should be aware of this. And when you choose the seat of the arbitration, where the arbitration sort of would be legally placed, you need to choose a very so-called pro-arbitration country. For example, in England, there are almost no inarbitrable subjects. Probably you cannot submit that the tribunal cannot order party to be sent to prison, so they cannot sort of punish parties for crimes, but they can decide on the factual issues of a complex fraud, for example, which is otherwise criminal to the extent it relates to the dispute and to the agreement in question. There is also a question if a party can submit dispute to arbitration at all. For example, whether a sovereign entity, for example, a state company in Kazakhstan, is authorized to submit dispute to arbitration. There may be also constitutional limitations on that as well. So when you sign an arbitration agreement, you also need to consult with the local lawyers, like Kazakh lawyers, to know if the company can sign an arbitration agreement at all. We'll now move to the legal framework for arbitration. So again, as I've been mentioned before in different aspects, there are different laws you need to be aware when you have an arbitration dispute. First of all, there is a law of the seat, which determines procedural and evidentiary matters. Often in an arbitration agreement, you will see words like the seat of the arbitration would be London, or the seat of arbitration would be Paris. This doesn't mean that you would have a physical hearing in London or Paris, but it means that all the procedural aspects of the dispute would be determined by the law of England, for example, in case if you choose London, England as the seat of the arbitration. And for example, if you need assistance from the courts, for example, if the other side doesn't show up and doesn't choose an arbitrator, or if you need to make an urgent relief, for example, for preservation of evidence, and the tribunal cannot give it, you would often go to state courts of the seat of the arbitration. As an example, some time ago, I had a dispute with a seat in Madrid, but hearings in Paris. So all the hearings happened in Paris, all the key decisions were made in Paris. But when the other side lost and they wanted to set aside the award, they needed to apply to Madrid High Court, and they had lots of proceedings in Madrid. Then there is a law of underlying contract. So you would say this contract is governed by laws of Kazakhstan. And then you would need to refer to Kazakh law to determine which side is right and which side is wrong, and to resolve the dispute. Then you may also have law of arbitration agreement, which can be separate from the main agreement. I'll speak about principle of separability shortly. But basically, you can have different law for the main agreement and for the arbitration agreement. Sometimes it makes sense if you choose, say, law of Turkmenistan as applicable law, but you don't know you don't know the aspects of how Turkmenistan law governs arbitration agreements and so on. And in that case, you may want to choose different law for the arbitration agreement, for which you are sure to have a stable dispute resolution process. It's generally quite rare to have different laws applicable to the contract and arbitration agreement, but sometimes it can happen. And then you need to consider the law of enforcement. Again, the whole point is not just winning the case, but also being able to get the money from the other side, even if it refuses to comply. In that case, you need to check where they have assets. For example, again, the Kazakhstan company may own a building in Paris, or may have a subsidiary company in Germany. And you need to check, or at least be aware of French laws and German laws in this case at the outset to determine how you would enforce the decision if things go wrong. Yes, and basically all of these laws can be derived from international and domestic legal sources. So you would still have the New York Convention to consider and various other regional conventions as well. So what are key legal sources? The most important, which I mentioned, is 1958 New York Convention on the recognition and enforcement of foreign arbitral awards. It basically sets the maximum standard. So it says when you can set aside, sort of annul the arbitration decisions, and for which reasons courts of any country can refuse to enforce the decision against the other side. States can make their rules more lenient than it, but generally it is assumed that they cannot make it harder. Now, in practice, some states would make it harder. For example, it's known that in some countries, courts are not as experienced in arbitration, and they may just not know how New York Convention works in practice, and they may make things more difficult. But in general, if a country has signed New York Convention, you at least have a procedure for enforcement, and it should be quite simplified. It's signed by the vast majority of the countries in the world, 170. There are very few countries haven't signed it. One of the most recent joiners was Turkmenistan, which signed it a couple of years ago. So at the moment, it covers all Central Asian countries. So what it regulates? It regulates what form should arbitration agreement have and when it's valid or not, or invalid. And it poses obligations on the countries. So they must recognize valid arbitration agreements and refer parties to arbitration. In practice, how it happens, if the other side refuses to comply with the arbitration agreement and starts a case in state courts, you should be able to object to it And before you make any substantial submission, so that before you submit statement of reply or anything, you need to tell the court there is an arbitration agreement, you need to refer the case there. And in most of cases, the court needs to refer this case to tribunal and stop the proceedings. And they must recognize and enforce arbitration awards. Then you need to also consider the domestic legal sources. So for example, in England and in many other countries, you would have a dedicated arbitration act, which specifically applies to arbitration. Sometimes you may have different laws for domestic arbitration and international arbitration. So obviously check if you have a domestic case, you generally would not be able to use the international law and vice versa. In England, we have exactly the same law for domestic and international arbitrations. There are some sections of the law does not apply to international arbitration proceedings. Some sections apply only to domestic, but in general, it's very similar procedure. In France, for example, it's governed by the Code of Civil Procedure. So they don't have a dedicated law. It's just part of the provisions of the Civil Procedure Code. In some countries, they have dedicated laws on private international law, which also cover arbitration. Switzerland is a good example. In most of countries, they would have some version of UNCITRAL model law of arbitration. Again, if you do the V-smooth, you would most likely have the law of the seat, which would be based on UNCITRAL model law. It was developed by the United Nations in 1985, and it's regularly updated. The latest sort of significant revision was 2006, but there have been also some changes in 2010 and later, but very minor ones. It doesn't have binding force. United Nations establishes sort of inspiration for the governments. So the governments would usually take it as a template, and they may change some parts of the law and the rules, but in general, you would have the similar procedure in more than 100 countries which have adopted it. And many Central Asian countries have adopted it as well. I don't think Kazakhstan has, but I haven't checked recently. I think Kazakhstan has a sort of dedicated law of an arbitration, but more than 100 countries would have it. You need to be very careful because first thing, if you have an UNCITRAL model law country which have adopted it, you need to check what it has changed. You cannot assume that it adopted the UNCITRAL model law in a sort of original form. But in general, the procedure would be very simple. And if you have an UNCITRAL model law adopted in the country, you can be reassured that the procedure would be quite clear because it's very comfortable and it works quite well. Then you need to consider the soft law sources. So if you start sort of working in the world of arbitration or going to conferences or doing actual arbitration work, you would see that there are so many different organizations. A lot of them are established by the International Bar Organization, which is sort of international representative organization of lawyers. It has international committees. I'm sure there is a committee for Central Asia. There are big committees for every country, and they determine legal standards, often considering legal traditions from different countries and guidelines. It's not mandatory, but it's a very good guidance. Tribunals would often say that they would apply IBA rules on evidence, for example, in the proceedings, because they're familiar to both parties. And UNCITRAL, sort of the UN body which determined the UNCITRAL model law, it also developed different rules on how proceedings should be conducted. And you would often refer to them as a golden standard when you argue about something. There is an interesting argument that IBA is very heavily influenced by English and American legal systems. And it's quite unfamiliar. For example, there is a so-called procedure of document production, where you can request where both sides request each other to submit a lot of documents, and then there is a whole procedure. It is also called discovery sometimes in the US, where you can get thousands of documents of the other side if they are relevant to the dispute. This almost doesn't exist in civil law countries like Kazakhstan or Germany. And at some point, just before the COVID pandemic, so in 2019, I think, or 2020, they determined a separate Prague rules on taking of evidence, which were based on the civil law traditions. I don't think they are used as much because arbitration at the moment is heavily influenced by English and American legal tradition. But still, if you want to have an option of using more sort of familiar procedure, which is familiar to you as a Kazakhstani lawyer, you may choose Prague rules and they'll work just as well. They were developed by lawyers from major law firms and very big representation of lawyers. So the relevant sources would be, again, coming in England, you would first check the Arbitration Act. It applies to domestic and international arbitration, but you should be careful because some countries have, England is not formally a federation, but we have different countries within the country. For example, Scotland would have a different arbitration law. So you should never say that we would apply the British law or the seat of arbitration would be the United Kingdom or Britain, because actually Scotland has a different arbitration system. And the English Arbitration Act actually applies only to England, Wales, and Northern Ireland. Same with the United States. You should never say the American law, because New York has very different arbitration law from California or other states in the US. It has mandatory and non-mandatory provision in England, which is quite interesting. So you can say we don't want Section 69 of the English Arbitration Act to apply to our case, and it won't apply then. Not all the provisions are not mandatory. You need to be, you need to know about the law. They would usually say that they are not mandatory, but you need to know this. And it establishes the foundation. So the Arbitration Act would typically say the duties of the parties and the tribunal, that the tribunal should be impartial and so on. So it would determine the fundamentals of the dispute. It will set the powers of English courts to intervene in the case, procedure for set aside of the or annulment of the decision of the arbitrators, how the words are enforced, and the limited scope for appeal. For example, again, you need to check local law very carefully. For example, in England, one of the features is that if the dispute is governed by English law, the court may, if the tribunal made a mistake, if the court thinks, the court can review the decision of the tribunal on the question of law, but not fact. But you can opt out of it because it's not a mandatory rule. You can expressly say that the courts of England cannot appeal the questions of law. But you need to know that. You may also want to check the Civil Procedure Court, or in some post-Soviet countries, it would be the Arbitrage Court, for example. You may have two court systems, the civil courts and the arbitrage courts. Check the relevant civil court. In England, this would be the Supreme Court Act and the Civil Procedure Rules, because they may also have rules in addition to the Arbitration Act or arbitration law. And then there are international law sources like the New York Convention, which I already mentioned multiple times. There is also ICSID Convention, which again is more relevant to the investment arbitration session, which you will have later. And there are also various other bilateral and multilateral international treaties like the Energy Charter or investment or different bilateral investment treaties, which are relevant to the arbitration context as well. Moving on to the topic of arbitration clauses. So an arbitration agreement would be an agreement in writing that the parties would resolve the dispute by referring it to arbitration for the final determination. Typically, you would have again, if you have a simple sale of goods contract where, I don't know, you sell 100 barrels of oil to the other country, you wouldn't have a complex arbitration provision. You would have a very simple arbitration clause. But if you have a multi-billion dollars or multi-million dollars contract, you would typically have a very complex provision, which would specify the governing law and various aspects of arbitration. It can take several pages, and it can be very complex sometimes. In principle, such arbitration clause would usually extend to only one contract, but you may have sort of so-called umbrella contracts where you say that this contract and this arbitration clause applies to other arbitration agreements. Sorry, not to other agreements signed by the parties. Ideally, you should also have small arbitration agreement in those contracts saying that if there is a dispute, it would be governed by that other agreement. So basically, you may have a network, but typically an arbitration clause by default applies only to the contract which contains it and to the parties who signed it. The key principle for arbitration is doctrine of separability. So an arbitration agreement is separate from the underlying contract. Usually your arbitration act or the civil procedure code would expressly say this. Basically, if the main contract is invalid, for example, for the reasons of fraud, or if one of the parties didn't have the right to sign this contract and to represent the company that signed it, then the arbitration clause would still survive this process. And you would still be able to submit the case to arbitration tribunal, who would hopefully decide that this doesn't apply, that the contract is invalid, but it doesn't immediately invalidate the arbitration clause. It basically exists separately from the main agreement. And to make it invalid, you need to prove that the clause itself is invalid or illegal. It's also why does this procedure exist? Because it basically ensures that if the contract is terminated, the parties can still submit it to arbitration and resolve the disputes arising out of the terminated contract. You can also choose, as I've said before, you can also choose different laws applied to the arbitration agreement and to the contract itself, which also can be helpful, particularly where you want to choose a more pro-arbitration law or more developed arbitration law to apply to the arbitration clause. There is also so-called doctrine of competence, which means that arbitration tribunal should determine its power to review the dispute, its jurisdiction, and the state courts, for example, cannot interfere into this. Again, if you do the VSMOD, probably the doctrine of separability and competence would be very relevant for you, and it's two foundational stones of arbitration procedure. In general, there are 6 key elements you must have an arbitration clause. It's quite my arbitrary list. There is no list saying that there should be these 6 elements, but in general, if you are working on an arbitration clause, and even if you don't work with many international disputes, you may even have it for 2 Kazakh companies in case of domestic arbitration. So you must have agreement to arbitrate. As you remember, arbitration is a creature of consent. So you need both parties to consent to arbitration. And I'll talk about it a bit later. But basically, you need to be very careful how you to formulate the consent and what it covers. You need to say the procedural rules which would apply. So, for example, in Kazakhstan, you would often choose the Astana International Financial Center Arbitration Court rules. Or if you want to have an international dispute in London, you may have the London Court of International Arbitration rules, and so on. Then you need to choose, say, the applicable law to the arbitration agreement. Again, this can be separate from the main agreement. Ideally, it should be separate. So you want to say that this arbitration agreement is governed by the laws of England and Wales or Kazakhstan. And it's very good to specify this because it may cost your client a lot of money to argue what is the applicable law to the arbitration agreement. It's very good to specify this. Then you should say the seat of the arbitration. Again, the seat doesn't need to be the place of the hearings. As I've said, I've seen cases where all the hearings happened in France, but the seat legally wasn't in Madrid. And for all the sort of legal assistance from the courts, for the annulment of the decision, all of this was decided in Madrid courts, in Spanish courts. Also, if you specify the seat, it's also recommended to specify the place of hearings as well, because otherwise the tribunal would be able quite easily to decide it. It's not sort of deadly if you don't say this, but this distinction would also help. You should also specify number of arbitrators and method of their appointment. I'll give you an example of this. Basically, you should not make it overly complicated. Usually it would say there'll be 1 arbitrator appointed by this particular institution, or you would say 3 arbitrators, 2 appointed by the parties, and the 3rd chosen by those 2 arbitrators or an institution. You should not make it too complicated. For example, it's generally not recommended to say that this particular person will be an arbitrator, because who knows what would happen in 10 years? This person may die, or may be sick, or may retire from legal profession. You never know what would happen. So generally, it's not recommended to name a particular person to resolve the dispute. You also shouldn't, sometimes parties say that they must have 5 years of experience in this particular industry, or must have PhD degree, for example, or whatever. It's also not recommended to have it because in certain circumstances, it may limit the pool of available arbitrators, and you would sort of make your life much more complicated and may be forced to choose a person who is actually not as qualified as you thought they would be when you signed the contract. And then you need to choose the language of arbitration, because again, language can be problematic. I'll talk about it later, but if you don't choose language of arbitration, you may have 2 languages. For example, again, if a contract is between a Kazakh and English company, you may have a bilingual arbitration where everything must be submitted both in Kazakh language and English language or in Russian language. And then you would spend a lot of money on translators and your client. And it's preferable to have 1 language. But if you have a state company, say from Kazakhstan, sometimes you may have requirements to translate every document so that the other side translates, for example, all submissions into Kazakh or Russian, so that it's easier for the government to work in this dispute. For example, in one of my Latin American cases, the relevant international convention said that all the documents must be translated into Spanish and submissions. So they can be submitted in either English or Spanish, but then they must be translated within 2 weeks into the other language. This again makes things more complicated and more expensive. But from the purpose of a government that agrees, for example, to have a dispute in international forum, it may make sense because it will make easier for the government officials to work with with the language that they know. So what is an agreement to arbitrate? The first element. So it means that the agreement usually should be in writing. Actually, it's in 99.9% of cases, it should be in writing. English Arbitration Act, for example, specifies this. The New York Convention also says that it applies to agreements in writing. So an oral agreement to arbitrate, it's extremely rare and it's extremely not recommended. Then it should be between 2 parties who have legal capacity to submit disputes to arbitration. Again, if you have a company, you must ensure that the director who signs the agreement is authorized to submit disputes to arbitration. If you work with the government, you need to ensure that the government person who signs it, again, is authorized to bind the country or the state corporation to arbitration. It's very important to check the capacity because it may end up to the annulment of the award or the tribunal refusing jurisdiction. Also, it's very much recommended to have very mandatory language in the arbitration provision. So you should never say may or might submit. You must say must submit, shall submit. So that, again, there is no dispute that the parties actually made it optional to go to arbitration and not to state courts. Moving on to the scope of arbitration agreement. Again, I've actually recently advised on a contract which has an arbitration agreement and basically explained to the client how it works under English law. It's generally advised to say that the agreement applies to both contractual and non-contractual disputes. This would, for example, involve torts or delicts, as they're often called in civil law countries. So if there is a delict related to the compliance with the contract, you would also have the same tribunal to decide it. It would also say the disputes arising out of contract or and relating to it or in connection to it should be covered in the arbitration. Because again, if it's a related dispute, but the arbitration clause doesn't cover it, you may end up with having arbitration proceedings and then court proceedings related to these things in parallel. They may come to different conclusions. One proceedings may take more time than the others. It'll end up being more expensive, more difficult for both parties. And in the end, you will waste a lot of time just deciding which part should be decided where. It's also wise to say that any and all disputes are covered by the arbitration clause. In England and Wales, an inviting case, for example, recommended arbitration clause. We often recommend the clients to say that this dispute relating to existence, validity, interpretation, construction, performance, and termination of the agreement, all of this should be governed by the arbitration clause. Because again, you cannot underline how important it is to have the wide arbitration provision and to have all these words there to avoid having multiple sets of proceedings and related expenses and waste of time. You should also check, obviously, whether, for example, in Kazakhstan, disputes arising out of intellectual property or can be submitted to arbitration before signing an arbitration clause. There are also optional clauses where they say the parties can choose whether they want to go to national courts or to arbitration. In this case, you need to say that once this selection is made, it's final. So you cannot change your mind after you submitted the case to the courts or to arbitration. There are also so-called unequal arbitration clauses, where it says that one side can submit dispute to arbitration or litigation, and the other side must submit it only to arbitration if they started. It's mostly typical in banking industry, so where you have a big sort of large bank lending money to a company or an individual, and they say that the bank can submit the dispute to the courts or to arbitration, but the person or the company can submit it only to arbitration. So why does this happen? Because the bank has much more bargaining power. They're usually stronger because they're giving money to the other side. And sometimes it may be quicker for them, especially if it's a small dispute, to submit it to the litigation. And if it's a complex dispute, to go to arbitration. And often stronger parties would push for such one-sided arbitration clause. In most of cases, this would be legal. There are some countries where it's arguably sort of the courts may look at this agreement, unequal arbitration agreement, with skepticism and may not enforce it. But in England, in Wales, in France, in Germany, in most of major arbitration jurisdiction, this should not be an issue. And this flexibility may be useful when you want to have freedom to decide to submit smaller case to national courts or larger to arbitration, or more specialized case to arbitration or simpler case to national courts. But if you have this sort of optional clause, you definitely need to hire outside lawyers or have a very experienced lawyer in your company, because it can go very wrong if you don't formulate it correctly. For example, don't say that the selection is mandatory when it's made, and so on. So in general, I would prefer not to have it, but if you have it, you need to get legal advice. So there are different types of arbitration institutions. As we've said, as you remember, there is institutional arbitration and ad hoc arbitration. In institutional, you have a huge selection of institutions. So the biggest one So can you guess which out of these 6 arbitration institutions here is the biggest one, handles most of cases? Can someone write this in the chat without Googling it? And I'll have some water. I think we got 5. I'll give you a bit more time. So I think we got a lot of ICCs, 1 Stockholm and 1 London. Actually, the answer is that it's LMAA, the London Maritime Arbitration Association. Because most of shipping disputes, for example, when the goods are not delivered or something happens at the sea, they're very small. There is a special arbitration institution, which is called London Maritime Arbitrators Association, which handles thousands of cases every year. There's also an insurance organization as well. I don't remember its name right now because I don't deal with insurance disputes, but it also handles arbitration. It also has a lot of cases. But from what I remember, LMAA is the biggest one because they handle thousands of shipping disputes. They're usually very small. They're usually resolved very fast. Then you would have large institutions like ICC and LCIA, which also handle a lot of disputes. For domestic arbitration in the US, AIA, American Arbitration Association, or ICDR. So one of them is domestic and one is for international disputes. They also handle thousands of cases because in the United States, you would see a lot of employment contracts, for example, have an arbitration clause. So if a person is fired for wrongful reason, for example, they need to go to arbitration. They cannot go to state courts to argue with this. So in the United States, you would have hundreds of thousands of arbitration cases in domestic scenario. But for international arbitration, it will usually be LMAA. Obviously, for not maritime disputes or commercial disputes, you would often go to LCIA, which is London Court of International Arbitration. And I think it's more than 100 years old. I think it's even older than ICC. Then you would have ICC in Paris, which is also one of the oldest arbitration institutions and most respected ones. Stockholm Center, I actually interned there in 2014. Also very good arbitration institution in Stockholm. It's particularly popular in post-Soviet countries because sometime in 1970s, I think, the Soviet Union and the United States signed an agreement in which they agreed to submit most of their disputes, economic disputes and commercial disputes, to Stockholm, because Sweden was viewed as a very neutral country for both the capitalist world and the communist or socialist world. And even after the Soviet Union collapsed, it's quite popular in post-Soviet countries because there is a whole generation of lawyers who have submitted disputes there and who respect and just like Swedish courts and Swedish arbitration traditions. But again, the disadvantage of Stockholm is that if you want to set aside the case at the day award or need assistance of the courts, you would need to hire a Swedish lawyer because obviously Swedish courts would not use English language in their proceedings. But the good news is that there are a lot of very good Swedish law firms that can help you with this. And so it comes with advantages and disadvantages, but Stockholm Arbitration Court, particularly for oil-related or gas-related or energy-related disputes, is still very popular in post-Soviet countries. And then obviously you have financial centers like IFC, the Astana International Financial Center, which have both their own court and their own arbitration institution, and which have great facilities for arbitration and which sort of base their procedure on some of the best international standards and often apply almost sort of unchanged English laws, which you can also look at if you want to have cheaper dispute resolution, which is more local. In ad hoc arbitration, you would not have an arbitration institution, but the parties basically would determine the rules how to appoint the tribunal, and then the tribunal would have almost free reign to determine different parts of the case to the extent these are not already determined by the parties. Yes, so it's usually wise to agree to apply UNCITRAL or other established arbitration rules, but you can also say that the parties can determine everything in the tribunal. Then you have the advantage would be you would have complete flexibility, but then a lot can go wrong. So basically, ad hoc arbitration, it's very flexible. It has a lot of advantages, but it usually works well only when both parties agree and want to resolve the dispute. If one of the parties does not want to participate or doesn't, for example, pay the cost of the arbitration, you may have a lot of problems in ad hoc arbitration. So yeah, Speaking of advantages of each system, so in institutional, you would have the institution which has trained lawyers. So for example, if you want to start a career in arbitration, it's a good idea to do a short internship in sort of Stockholm Arbitration Court, in ICC in Paris, or ICC also have, I think, Hong Kong division, in London, and or in IFC. These institutions have their internships, they have staff on the ground, which have handled hundreds of arbitration cases and which can help you with any aspects of the dispute, constitution of the tribunal if other party refuses to nominate an arbitrator, administrative matters, paying the arbitrators. They would have a procedure for this. They would have people who have handled hundreds of cases like this, and they would be very helpful to you. In case of ICC, for example, would also check the arbitration award for quality and determine that and may ask the tribunal basically to clarify some points which they think are not clear enough, and so on. So basically, in case of ICC, you would have third-party review of the arbitration award, which would ensure that it would be enforceable after it's been issued. It's a bit controversial. Some people don't like it because you appoint arbitrators for a reason, but also it establishes some quality control. It's generally more secure because, again, if the other side really doesn't want to participate in arbitration, there are a lot of ways it can make life more difficult, both for arbitrators and the other party. And here you would have a bit more security for that. But also it can be more lengthy and more expensive because you need to pay the ICC, for example. You need to pay the arbitrators. And ICC fees are quite high, and they come in addition to the arbitrator fees. In ad hoc, again, if you have recalcitrant, not compliant other respondents, so that the side you're suing, you may have a lot of problems. Especially they are sophisticated arbitration users, they can make your life difficult on many levels. You don't pay to institution, so it costs a bit less, but you may need to pay more to your lawyers if the other side is not compliant. Usually states like ad hoc arbitration because this allows them more flexibility and more respect to their sovereign rights. But for example, a lot of African states would submit their disputes to ICC as well. So I wouldn't say it's a sort of definitive point. And ICC would also respect state sovereign rights, or LCIA as well. What else? So which institution to choose? I think at this stage, we have come to the point where all major arbitration institutions would have very developed sets of arbitration rules. So I wouldn't say that you would lose by choosing ICC or LCIA or Stockholm rules or IFC in Kazakhstan, because all of them would have very similar arbitration rules. There are a lot of small print points you need to consider. For example, in some arbitration rules allow you emergency arbitration, where before the tribunal is appointed, you can immediately apply for a person. Like, for example, I think American Arbitration Association was the first to develop it in 2006. So basically, within 24 hours or 48 hours, depends on the rules, you would have a person appointed who would immediately make a decision. Sometimes within a week, sometimes within 5 days, again, depends on the rules. And you would have already it resolved even before the tribunal is appointed, which may be an advantage. Some people like this, some people don't like this. So you may need, also, for example, some institutions like ICC have very developed expedited arbitration rules. If you want to have your dispute resolved within a year or year and a half, you can apply them, and it's definitely an advantage. So but it's all like small print minor advantages. I would say you can't go wrong by choosing LCIA or ICC rules. All of them are very similar to each other. Case administration. In case of some institutions like ICC, you would have a lot of interference from the court. ICC considers that needs to sort of establish consistent work product from arbitrators, consistently drafted awards. So ICC is very interventionist, and they would try to determine a lot of issues. Then there is issue of remuneration. Again, some arbitration courts like ICC, I think, the cost of the arbitration, how much you pay to the institution, depends on the value of the dispute. So for example, if your dispute is $1 billion, you would pay a certain percentage of this billion to the ICC, regardless of the decision. While in other institutions, you would only pay the hourly fee, sort of how many hours ICC staff worked on the case. You would pay only for that. Not ICC staff. In ICC, it's ad valorem, so based on the value, but in other institutions, it can be hourly payment. And then you need to consider international reputation, because as you may know, especially in some post-Soviet countries, for a while there was a phenomenon of pocket arbitration courts. So what would happen is some chamber of commerce or some local company, like a big energy company, would have their own arbitration court. And when they sign an agreement with somebody, they say, all the disputes should be resolved in our affiliated arbitration court. And obviously, all of the arbitrators who are in the list of this arbitration court, they would be getting a lot of the arbitration work from this company. So arguably, they won't be, you can't say that won't be impartial. They're still subject to the standards established by the local laws, but also they have some financial interest to continue to be the list of the arbitrators of this company and sort of affiliated with this. It was very controversial. It was very big in countries like Ukraine, Russia, and other post-Soviet countries. I think now most of these pocket arbitration institutions are sort of zoned out. I think they were closed or they're very small and almost not used. But it was very popular in sort of in the middle of 2000s and early 2010s. And it was viewed as a real threat and to arbitration, and their decisions were often not enforced because there was no credibility behind these institutions. There was also a very famous case, I think, in Moldova, where it was a money laundering. So the parties wanted to launder $1 billion or something, and they basically invented an arbitration court. So they invented fake arbitrators, drafted the fake awards in the name of these arbitrators, and they tried to enforce it in courts so that the money exchange happened and was legalized by the arbitration. And basically, it won't happen if you have ICC or LCIA managing the case. You can be mostly reassured that it's a genuine arbitration dispute. You won't have anything illegal there. And the courts in other countries will look at it. It's ICC. It's a very respected institution, existed for hundreds of years. They supervise the cases. Most likely, they'll be more inclined to enforce the decision. And I see there is a question from Abdulin. I think I'll reply to all the questions in the end. So I'll check the question and reply to it. And please submit your question as you go, as you have them. So I'll go through the chat and try to reply in the end. Then, as I've said, seat of arbitration is different from the physical place of the hearings. Typically, when you choose the seat in the arbitration clause, you mustn't choose the country. As I've said, United Kingdom consists of several countries. So we have Northern Ireland, Wales, England and Wales, and Scotland. And for example, Scotland has entirely different legal system, or almost entirely different legal system from England. They would have their own, it's mostly civil law. It's not based on common law like in England and Wales. They have their own arbitration act, which is very different from English arbitration act, and so on. So you need to say, ideally, London, England, Geneva, Switzerland, because Switzerland also have different cantons, which may have different rules. Though I think Swiss in private international law applies to all of them, but still, you can never be sure about this. And again, in the case of the United States, for example, all of the 50 states and Washington, D.C. Would have their own sets of arbitration acts, rules, and so on. So you need to choose particular place and city. It must be as clear as possible. And when you choose the seat, you consider the neutrality, reputation as arbitration friendly, so that the courts won't interfere too much in the proceedings, quality and track records of the courts, and enforcement, that they are party to New York Convention, so that you can benefit from those like convention which allows you to enforce decision made in the New York Convention country in 170 countries around the world. And you would have London, Paris, Geneva, Hong Kong, Singapore, New York, Stockholm as popular seats. I think White & Case and Queen Mary University have done a survey, and I think London and Paris are the most popular ones, but Singapore is very close. And I think it came second in one of the surveys, actually. So I think London, Singapore, Paris, and Geneva are probably most popular ones. But also for domestic arbitration in the US, New York could be more popular. We're speaking just about international arbitration. You would be surprised that Stockholm is actually not that popular in comparison to ICC in Paris or London. But at the same time, it's very popular in particular regions, like post-Soviet regions, for example. You would see a lot of disputes still being submitted there. Then you would choose the applicable law. As I've said before, different laws apply to different aspects of arbitration. So you have the law of the seat, which is procedural law, which applies to the conduct of the proceedings. So if you need to go to local courts to challenge an arbitrator, or even if arbitrators decide on their own challenge, they need to apply the law of the seat. Rights of the parties, how you can set aside or annul the award, Then you have the law of the merits, which would determine who is in the right and who is in the wrong, and would determine which party wins the dispute, basically. And you have law of arbitration agreement, which governs what you submit to arbitration. For example, and if you don't choose it, you may end up in a sort of difficult disputes. For example, as it's set on the slide, on the English law, the law applicable to arbitration would be the law chosen by the parties. So if you made the decision, or absent such choice, the governing law will apply to arbitration agreement. But then you can see there was recently a big decision in ENCA and CHAB, which says that it's generally the law of the seat. But then you may argue, was there an implied choice of arbitration law and law applicable to arbitration agreement and so on? So basically, the good decision is to always decide what is the applicable law in each case to both the merits of the disputes and the arbitration agreement. And then you choose the procedure for the appointment of the tribunal. If you have a smaller dispute, you should usually appoint one arbitrator because it would be much cheaper to have one arbitrator in the dispute. If it's larger, it's always better to have 3. Usually it's 1 of 3, and always in an even number, because if you have 4 arbitrators, for example, what happens if 2 of them decide that the claimant wins the case and 2 decide that the respondent? You're basically deadlocked. There is no way to resolve this, unless you have some other strange provision that the president decides to resolve the deadlock, but it's very atypical. So sole arbitrator is much cheaper and faster. 3-member tribunal means greater scrutiny, but it also means you need to pay 3 members of the tribunal. It takes much more time to appoint them. Most of arbitration institutions would have 1 arbitrator for smaller disputes and 3 arbitrators for larger ones, and 1 as a default unless the parties want otherwise. So I see a question which sort of goes to the slide, so I'll reply prematurely. So why would you not want to have qualification specified? I think I partially touched on this before. So it's generally unwise to have too much information at this stage, because if you name a particular person, something may happen to this person, basically. If you check most famous arbitrators, a lot of them are there. Sort of very experienced lawyers with decades of experience, and they may get sick, they may retire. You never know what will happen in 10 or 15 years when you have the dispute. And if you make too much qualifications, for example, if you say that the arbitrator must be a British national who has 10 years of experience in construction industry and PhD in mining, for example, you may end up with having 5 people who satisfy all of these requirements and working as arbitrators in international arbitration, and all of whom are already busy working on different disputes and don't have physical time to take the dispute you have. And then basically you cannot appoint an arbitrator or first appoint to just 1 person, which kind of deprives you of the choice later. So in general, it's recommended not to establish too detailed provisions for qualifications for arbitrators. Hopefully this replies the question. And about the language of arbitration. So usually you would want to have the same language applicable to the contract and relevant documents in the arbitration, because this means that the tribunal doesn't need everything to be translated for them. And you would not spend much money on translators. You should also consider language which is spoken by the parties, likely witnesses. For example, I think my colleagues recently had a dispute in one of the Central Asian countries where they used Russian language, but for very international dispute. And it was very hard to find. And it was huge dispute, billions of dollars. And they needed to choose very famous arbitrators. Some of them were Swiss or British arbitrators who also can speak some degree of Russian, or at least have some exposure to the language and to disputes in the region. And one of the law firms in that case, most of the team were English speakers, so they also needed to have everything translated to them. And it was very complex, and it did not work too well from what I've heard. Also, arbitrators, especially good arbitrators, cost a lot. In one of my disputes, I had an arbitrator who was translating for Gorbachev when he was the head of the Soviet Union. And extremely professional person, very good, but also costs of good translators cost a lot, especially simultaneous translators. And you may spend a lot of money on this because you want to have a good translator in the dispute so that the tribunal would understand all of your points correctly. But basically, you need to consider all of these costs and considerations when you make a decision to have different languages for the main contract and for the dispute. Then speaking about neutrality, again, it may be unfair if you have a company, say from Kazakhstan, and a company from, I'm choosing a random, Pakistan, for example, and you have Kazakh and Russian on the one side and Urdu on the other. You may want to choose English language as a neutral one, because then it would be easier for both parties. And if you have several languages in the contract, which sometimes actually happens if you work with the government, particularly, you may have some agreements in different local languages and the main agreement, investment agreement or other agreement in English language. You may also want to choose English or more neutral language. You may have dual language arbitrations. I had cases where everything was simultaneously translated into Spanish, and I know of cases where it was translated into other languages so that all the witnesses and participants can understand everything, but it increases cost, basically. Simultaneous translators, it's a very difficult profession. They cost a lot of money, especially the good ones, and you need to be aware that you would have significant expenses on the translators of quality. Then I see some other questions, but I will respond in the end. I responded to the previous one just because it was literally to the point on the slide. You may have escalating and multi-tiered arbitration clauses. So sometimes, especially in sort of large construction contracts, you may have multi-tiered arbitration clause. What this means is that you separate dispute resolution in several stages. So you would first want the parties to negotiate between them for, say, 3 months or 2 months. You should usually specify the period. Then you would have mediation provision where you have a mediator, a party, sort of a professional person who is experienced in this field. Sometimes you may require him or her to be certified in mediation, who will try to help parties to reach sort of the middle ground and to resolve dispute before it goes to arbitration. Sometimes you might have an expert to determine technical disputes or dispute resolution boards, sort of 3 experts to rule on the technical aspects of the dispute. And only then the case goes to arbitration. Where this works most is, for example, construction industry, where you have a FIDIC set of contract, for example, which is very popular. It was developed a lot of years ago. There have been many editions, and they have a very complex arbitration provision, which basically provides for negotiation and I think sometimes engineer determination. Then you would have dispute resolution board, sort of 3 experts who make a decision, and then you have arbitration. Why does it apply? It applies so that the project doesn't stop. Basically, often if you submit arbitration claim, the parties hate each other, all of the work stops, the project doesn't go forward, and you have several years of arbitration proceedings and everything is dead. While having a more flexible negotiation and dispute resolution board procedure may allow the project to still go forward while minor disputes are being resolved as the case goes on. You should also be very careful about drafting a multi-tiered arbitration clause because things can go very wrong if you don't specify when and how things happen. So how does this work? So if one of the parties, for example, you have negotiation, expert determination, and then arbitration. If the claimant, the party who starts the case, doesn't do negotiations and then expert determination, tribunal would generally refuse to hear the case because it's inadmissible. The party hasn't followed the required procedure to submit the dispute. If the tribunal is convinced that compliance was futile in some cases, for example, if the parties could not agree on anything, it's obvious that the parties cannot cooperate. In rare cases, the tribunal may decide that it was necessary to comply. But if you have a multi-million dispute, you would not want to risk it and just not comply with the procedural requirements to negotiate or to notify the other side about the dispute before submitting it to arbitration. So how would it work? You must clearly indicate whether each tier is mandatory, and a good drafted multi-tiered arbitration clause would say that the parties must submit the case to negotiation for 3 months, and then if the case is technical, for example, they can submit it to an expert, but if it's not technical, they can go straight to arbitration. Or you say that expert is mandatory. So basically there are different procedures, but you need to say what is mandatory and what is not to avoid the disputes about whether parties complied with the procedure or not. You should clearly say what each stage can determine and when it ends. For example, you need to say how many days or months the negotiations should take place and so on. You should say how the expert or the mediator, for example, should be appointed. And you should try to limit pre-arbitration tiers in time so that you don't end up having negotiations for a year and then mediation for half a year, for example. And examples of such clauses, for example, the parties will attempt to negotiate a settlement of any claim. And then you say how many days it would take to do this and what happens if they fail to negotiate a settlement. If the matter is resolved by negotiation, the parties will refer the dispute to mediation. And then you say how the mediator is appointed. There are some sets of mediation rules as well, but you don't necessarily need them. And the timeframes, how much time the mediation should take place. If the parties fail to agree upon terms of a settlement within 60 days from the time it goes to arbitration. So this is a typical multi-tiered arbitration clause. It would obviously be much longer in practice. Probably it would take at least a page if it's well-drafted one and detailed one, but this is how it works. Then you may also want to consider additional things. For example, you may say that the dispute would be confidential. You may want, and again, USAN and people who have participated in the Wismut last year know that you may want to say that a third party can join the dispute, or disputes between this contract and that contract can be consolidated with each other to make it easier for the tribunal to deal with the multi-party disputes. You may want to expressly say that expedited provisions under ICC rules, for example, apply or don't apply. Emergency arbitration provisions apply or don't apply. And it's not recommended, but you may also say that IBA rules on evidence supply or Prague rules, for example, on evidence supply to this dispute to make it easier and more straightforward for the tribunal. But in general, the tribunal should be able to decide on this itself. And you obviously need to check that this multi-party provision works, or other expedited provision works with the general arbitration clause. So this is how model arbitration clauses look like. So this is LCIA arbitration clause. So as I've said to you, it's very important to say disputes arising out of or in connection with the contract, because this covers all types of dispute, not that direct breaches of provisions of the contract. I would probably add here contractual and non-contractual dispute, just in case, to ensure that it covers torts or delicts. Then it's good to say existence, validity, and termination. They specify LCIA rules here, and they say that the rules are incorporated in this clause. Sometimes it's good to say the rules as they are enforced when the dispute is started, because otherwise you may be locked to the old edition of the rules. But it's not necessary in all cases. Then you ideally should say the number of the arbitrators, the seat, the language, and the governing law of the contract, and arbitration clause ideally as well. So here, for example, LCA doesn't have law of arbitration clause, which I would probably include. This is the IFC clause, for example, the Kazakh International Institution. So here, I would say I like it in a way a bit more because it says contractual and non-contractual disputes. It also says any dispute, controversy, or difference. Again, very extended provision. It's similar to LCA clause before. It has arising out or in connection. And it then gives different situations, interpretation, performance, breach, and termination, and so on. It also refers to the mediation rules, in case the parties want the mediation rules to apply as well. As I've said, it says enforce on the date on which the arbitration is started, which is also something which I would include. And it says incorporated in this clause. So actually, I think the IFC clause, for example, in a way, it's closer to what I would, for example, include in the dispute resolution provision. Because it's wider and it covers a wider range of scenarios. Though I'm sure LCIA clause works perfectly well as well in most of cases. And this is an example of an ad hoc arbitration clause. As you can see, it's a bit shorter. It says any dispute under UNCITRAL arbitration rules. What key difference is it has the appointing authority. So the institution or person who appoints the arbitrators, if there are problems with the appointment. And it has more detailed provisions on the number of arbitrators, usually, and so on. So now I'll have an interactive exercise for you. I'll give you 5 minutes to look at this clause on the screen and tell me what you think are problematic provisions. So can you write this in the chat? Based on what I've said before. Okay, actually, a lot of replies, so very interactive audience. So I think I'll give you 1 more minute, and then you can probably start. So I think you identified most of the issues. Let me just quickly check for your replies. Maybe, must be. So I think a lot of you identified the language. So it says may. I don't think shall is as problematic because it's still quite mandatory on the English law. I would probably also prefer must, but shall would work in general. But for example, it says that the parties agree that any dispute may be referred to arbitration. This is a problem because a party which wants to disrupt the proceedings may want to say that it's optional and it can be submitted to the courts. And this can cost a lot of money proving that it does not. And this is a mandatory provision. A lot of you have identified the number of arbitrators because it's two. And again, it can be a problem because the arbitrators appointed by the claimant and respondent can disagree. It's always good to have the president, the third arbitrator, who can sort of decide and make the casting vote and resolve the dispute. Yeah, and yes, again, that it says disputes arising of this contract. As you may remember the previous clauses, they said disputes arising out of or in connection with the contract. Again, like one of you has pointed, non-contractual disputes. It's usually, especially in case of England, it's usually English law. It's usually better to say that non-contractual disputes are included, and this is recommended by most sort of directories and most of guides for drafting arbitration clauses. The problem about the UK, again, is it Scotland or is it England or is it Northern Ireland? The rules can differ between them, and between Scotland and the rest of the sort of countries within the UK, they differ a lot. So good about that. Number of arbitrators. The language, again, there is nothing wrong between choosing Kazakh language in a UK-seated arbitration, but it may cost you because it may be harder to find arbitrators who speak Kazakh, or you may at least need translators, particularly if the main contract is drafted in English. And here we have an English language arbitration clause, which presumably means that the main contract is in English. So you may have, if you have Kazakh-speaking arbitrators, you may need to have some translators who work with the language and so on. So it may increase your costs significantly. So what are the problems? So a minor problem is that the contract is governed by Kazakh law, but the seat is in the UK. So this means, so you don't know what is the law applicable to the arbitration agreement. It's a bit unclear whether it should be the law of the seat or the law of the main contract. And you may have a costly dispute arising out of this. So in this case, it's better to specify that the law of this arbitration agreement would be Kazakh law as well to remove this inconsistency. What else? And I think that's actually all of the main problems. Let me just check because they have more replies. Obviously, it could be good to specify consolidation provisions and so on. Number of arbitrators, we should mention the exact city arising out of. Yeah, I think you got all of the rules pretty much. So good work, everyone. And I got a lot of replies. So the next problem, and again, please give replies in the chat. I'll just make a note where the previous reply stopped. Okay, I'll give you one more minute. Yeah, I'll slowly start checking the replies. So yes, I think you also identified most important aspects. This course was actually not that bad. The bad part about it, it doesn't have as many glaring mistakes, but it doesn't have a lot of important elements, which is better to say. For example, it does say language shall be French and or German. So what does this mean? That you have both French and German, that you have either of them? Who determines which language it should be? I think in this case, arbitrators would most likely be forced, if the parties disagree on this, to have proceedings in both French and German, which may cost you a lot of money, your clients, to spend on translators who would translate each provision into French, so each submission and each letter into French and German. And you may also need to have simultaneous translators during the hearing, which again costs a lot because, yeah, it costs a lot in practice. Then the reference to the institutional arbitration rules. Well, there are several. Well, there is obviously the largest arbitration institutions in Geneva. There are several of them. There is commercial arbitration centers. There is a sports arbitration center, CAS. There's just not just one institution in Switzerland and in Geneva in particular. So it's not specific enough. And while it probably won't make this arbitration clause invalid, it would cost you. It would if the parties cannot agree which institution it should be, they would spend a lot of money arguing which it should be. Non-specific language, actually reference to English law, I would probably use England and Wales. But again, if you have a pro-arbitration country like Switzerland or England, it would not be a deadly problem, and it won't be a very big problem. It should indeed specify shall be settled by arbitration in Geneva. Yes, it doesn't expressly say that Geneva is the seat of the arbitration, which I think one of you noted, or several of you noted. And it's good to say whether Geneva is the seat or the hearing place. I think, again, if there is a dispute about this and the court needs to decide by the parties submit this dispute to court to determine where the seat of arbitration should be, the court would probably decide that it should be Geneva here. But again, it would cost you a lot of money to determine this. But I think the most deadly sort of the problematic provision of this clause is the reference to institutional rules in Geneva, because it would definitely cost you a lot of money to resolve this. And the final clause. give you 1 more minute. Continue. Thank you. I'll start checking the replies. So I see contradiction about the applicable law, mention a lot different arbitration rules and the courts. I can see the point about 1 month. Options of institutions, no seat. And arising out of in connection point. So yes, this is much more problematic clause than even the previous one. Actually, I don't see as much problem in Article 53, because if you check Article 59 is this arbitration provision, as we discussed, there is a principle of separability, which says that the law, there can be different applicable law to the main contract and to the arbitration agreement. So actually, in itself, probably Article 53 is not that problematic. In most of cases, it's recommended for parties to have same law applicable to both, because just it will be easier for you later and cheaper for you to have lawyers qualified in the same law. But it's definitely not deadly. And in some cases, there may be advantage for this. So by itself, it's not a problem. But Article 59, as you correctly identified in the chart, has a lot of problems. So the main problem is, what if you have a dispute which involves both questions of interpretation and performance? Where does it go? Because here it says courts and the performance disputes to the arbitration. What it's both? What it's both? Often, if one thing goes wrong, a lot of things go wrong at the same time. So you may have a lot of issues going wrong exactly the same moment. Do you need to start separate cases in courts and in arbitration? Then it's just in general better to resolve all disputes in the same forum, either in courts or in arbitration. In this case, if the parties want to have different options, it could be better to say that the parties would have an option to either submit the dispute to courts or to the arbitration. And that after they started doing this, the selection would be final. This would work much better than this very ambiguous arbitration clause. The next one, as someone correctly identified, there is no seat specified here. Just because English courts are chosen for litigation doesn't mean that the English courts are the English courts in London and England are the seat of the arbitration. This can cause a lot of controversy and a lot of problems later on. And at the same time, the fact that the Article 59 is governed by English law doesn't necessarily mean that the seat would be England. Then what is the trigger event? Some of you said that 1 month is very short, but also what is the trigger event within 1 month from what? Is it 1 month from when the dispute arose or has arisen? Or is it one month within when the English courts resolve the dispute or when a claim is filed in the English courts? It's very uncertain, and this also can cost you a lot and your clients to resolve this controversy, and you may have multiple sets of proceedings because of this. And it also doesn't specify the language which applies to arbitration. So you have, again, the laws of Kazakhstan, which are available in Kazakh and Russian, and you have laws of England in another case. So again, it may be beneficial to have one of the languages chosen for the arbitration. Otherwise, you end up paying translators a lot of money. But as I said, the Article 53 on its own probably is not as problematic, because you can have different law applying to arbitration clause and to the main agreement. So thank you so much. If you could now write any questions that you have to the presentation, I'll go to the beginning of the chat and try to reply to the questions that you submitted already. So one of the questions is, if you write that LCIA rules are arbitration rules in the agreement, then you can apply only to LCIA. Correct if you say that the parties must submit their dispute to LCIA or shall submit their dispute to LCIA, then they must submit it to LCIA. As we have seen in the previous sort of wrong arbitration clause, you may have several rules, but I've almost never seen it in practice, and it's not recommended to have several sets of arbitration rules. As I say, most of arbitration rules by this stage are quite developed and good. So if you choose a well-respected international arbitration institution like LCIA, ICC, or IFC in Kazakhstan, you should most likely be fine with it. And the choice should be governed by other considerations. For example, particular features of those rules, availability of emergency arbitration or expedited arbitration rules, and so on. If the seat of arbitration is London, Great Britain, so does that mean that the dispute can be resolved in any arbitration center in London? Well, as we have said, the seat doesn't necessarily mean the choice of an arbitration center. But yes, you should ideally choose the particular arbitration center. As we discussed, there are lots of arbitration centers in London. And it's better to say LCIA or LMAA, the Maritime Arbitration Center, and so on. Is there no obligation to be an arbitrator if it was agreed before, even if that person has retired? Well, you cannot force a person to be an arbitrator. It's all based on consent. So if the person is retired or, I don't know, moved to another profession or just don't want to take the dispute because they don't have time to take the dispute because they already arbitrate on 10 different disputes at the moment, and they just don't have physical capacity to take this case, then you cannot force them to do it, and you have a huge problem. That's why it's not recommended to have too much requirements for arbitrators or even to name a particular arbitrator, because you may not have them, and then you have a problem. Probably if it happens in England, you would be able to go to courts and sort of try to get the courts appoint an arbitrator, but even that would be problematic because there is not much practice in such cases, and you never know what would happen in the end. Then the question about anti-suit injunction that subvert the separation between arbitration and litigation, ruling on jurisdiction applicable law. Well, anti-suit injunction under English law and the anti-arbitration injunction, there have been a lot of cases. It's one of the unique features of English litigation system that the courts can actually order the parties not to start case in other countries or not to start an arbitration case, which is submitted in violation of arbitration agreement of an agreement where there is a sort of mandatory jurisdiction of English courts, is one of the unique features of English courts, which is also one of the reasons why parties often choose to submit the case to English courts or English court system. It's a bit controversial because I know some countries in the European Union when the EU was still inside the European Union, were not happy that English courts sort of can make a mandatory injunction preventing the parties from going to the courts of the other country. But in general, it's a feature of English legal system for decades. Yeah, it works quite well, and it's usually considered to be an advantage of the English legal system that English court can order a party not to go to courts of another country which don't have jurisdiction over this particular dispute. Do you think consolidating two arbitral tribunals between the same parties into single arbitration generally correct, cost effective? Yes, in general, it's good, particularly if you have again, like the classic example of multi-party and multi-contract arrangement is a construction dispute, where you have employer, so the party which orders the construction, having the main contract with the contractor, the party who does the construction. Then the contractor may need to hire subcontractors, so people who would help them to build different aspects. For example, I don't know, the electricity, connect the electricity, and so on to the construction place. They'll have a separate contract with them. And obviously, if the dispute sort of covers all of the parties involved into this, it's much better to have them within the same set of proceedings rather than in many different ones. It will save you a lot of money, it will save you a lot of time, and you'll basically get it resolved quicker. So there's definitely an advantage in having all of this in one set of proceedings. So moving on to the bottom, new questions. And thank you so much. We have a very active audience today. There is a lot of questions. So main distinction between them is that in institutional arbitration, parties must resolve their dispute only by rules by specific institution like LCIA. And in ad hoc arbitration, they don't have such strict rules. Yes, because basically our institutions have prescribed set of rules. If you open LCIA website, you immediately see 2020 arbitration rules, which would apply to all the disputes submitted at the moment. Often rules say that unless the parties say that, say, previous edition of LCIA rules should apply, it would be the latest edition of the rules applicable to your dispute. While in ad hoc, you can say that the parties resolve their dispute in ad hoc arbitration or in arbitration under UNCITRAL rules. And you won't have an institution which would help you with various aspects of the case. For example, if one of the parties doesn't participate in the proceedings, or if one of the parties doesn't want to nominate an arbitrator, you won't have basically an institution which would help you to deal with these situations, which is why ad hoc is much more flexible, and it's much more flexible, and it gives the parties ability to choose everything, but it's also risky because if the other side wants to sabotage the proceedings, you may have a lot of problems and you won't have an authority which would help you with this. You may go to state courts, but this would at the seat of the arbitration. But this kind of subverts the purpose of having an arbitration, because why would you have an arbitration if you need to go to the state courts for every single procedural issue before the tribunal is appointed? I understand that IBA guidelines are mostly recommendations. Yes, IBA guidelines are recommendations, but at the same time, if you just check basically any arbitration proceedings on websites like UseMundi, you would see that when arbitration starts, the tribunal would usually choose to apply IBA rules on evidence or IBA rules on conflict of interest for the arbitrators, because they're well respected. IBA is very well represented organization. It has people from various countries in it, who are selected by local committees of IBA. And all these rules are developed by hundreds of legal experts. And basically they are viewed as a golden standard. Though obviously you can choose to apply different rules or not to apply IBA rules. In escalating multi-T clause, there are several rules to deserve. Yes, it's not recommended, obviously, to have several types of arbitrations inside. You need to have sort of one method of final resolution of the dispute, which would be arbitration or litigation. And then you may have to have, for example, expert determination for more technical aspects of the dispute. But usually the decision of expert would not be enforceable. So you won't be able to go to court and say that the other side needs to comply with it. Or in the same with the mediation and negotiation. I may not be able to share the presentation, but I'll check this with the Sen after this. So the quality of decision making. Obviously, if you have 3 arbitrators, so usually you would see the president being the most experienced person in the arbitration tribunal, and he or her would sort of be actually the person drafting the award while consulting with other arbitrators, though this can differ. So you're usually safe if you're the president of the tribunal is a very experienced person who has dealt with many disputes and who is very renowned in the arbitration field. But obviously, so yes, having 3 arbitrators compensates the risk of having a bad arbitrator. But yeah, so that's why it's better to have 3 arbitrators for more complex dispute, because it also gives you different perspectives, different experiences, and wider selection of people with wider expertise. How would we interpret the difference between the seat and venue? Which of them is preferred? The seat you would want to choose the arbitration-friendly country, where the courts have dealt with arbitration before. They've worked with arbitration a lot previously, and you won't get any unexpected decisions from them. And you know that the courts are not hostile to arbitration and don't want to subvert the parties' agreement to arbitration or not distrustful of it. About the physical place of arbitration, you would usually choose the most convenient place for the parties. For example, the both parties have offices in Paris. Paris has very good arbitration facilities, so it's very good to organize a hearing there. Or, for example, if it's hard to get visas to a particular country for representatives of parties from some particular country, you may want to have a hearing in Dubai about a legal seat in England. It's also possible to have it, and countries like UAE, for example, are much easier to travel, or Hong Kong, for example, or Singapore. So this may be an advantage if traveling to the United States, for example, or the UK or France may be difficult from people from a particular country, with nationality of a particular country. So there is a question about arbitration career. How to build a successful arbitration career, to which one should be dedicated. I think LLM is always a good experience if your financial means allow it or if you found a scholarship. Obviously, it's not a must, particularly if you work domestically. It also depends on the legal systems. I would say many people working in arbitration have LLMs, but not everybody does. Usually, LLM is a big advantage because if you spend 1 year studying in Switzerland or France or the UK or the US, you are on the ground, you're able to talk to local law firms, you go to the career events. It's just easier to find a job, but you don't necessarily need to have LLM to work in arbitration. When drawing a memorandum, what precedents can be used about the confidentiality of arbitration? It depends. Large law firms like mine would have precedent language in our templates, which is our proprietary language. We obviously would not share it outside of the law firm, but which we would use for preparing a confidentiality agreement. But there you can find some precedents in different legal books. There are books about arbitration agreements, which you can find on websites like Kluwer, and which would give you examples used in previous disputes or recommended by different bodies. In construction industry, again, you would have FIDIC concept of contracts, which have dedicated contracts, which already have developed arbitration provisions, which you can also use. The golden rule, if you don't have your own precedent, if your company doesn't have your own precedent, and even if you do have it, it's always good to get other perspectives, to check books about drafting arbitration agreements. They would often have a sort of a section which gives you examples, and to check the recommendations of different bodies or the courts like LCIA court. I've shown you the sample clauses of LCIA and IFC and UNCITRAL, so check them. If the courts has exclusive jurisdiction, can I recognize any arbitration rules? So this goes to the question of arbitrability. For example, in England, it's generally possible to submit pretty much any dispute to arbitration. England is a very arbitration-friendly country, but in some cases, the courts may say that disputes related from, for example, arising out of intellectual property cannot go to arbitration. In this case, a tribunal seated in England would most likely still accept the dispute, but you may have a problem in the end of this dispute when you try to enforce it in, for example, Kazakhstan or other country where it's not possible to do IP dispute, because local court would refuse it to enforce it, because the New York Convention has provisions on enforcement which say that dispute going against the public policy of a particular state, arbitration award cannot be enforced on these grounds by the national courts. So basically, exclusive jurisdiction rules may not prevent the arbitration, at least in arbitration-friendly country like England or France or say Hong Kong, but you may face a lot of problems on enforcement stage, and it's obviously better to avoid them because you may get an award, but you won't be able to enforce it against the assets of the other side and get your money back. What do you think about multilateral arbitration courts? Well, it's been debated for a while. It mostly applies to investment disputes. So I think you can also ask this in that section. But multilateral arbitration court, basically, it's been in the works for a while. I don't think there have been that many developments. There have been a lot of suggestions and discussions, but I don't think EU has presented sort of a concrete plan on this. So we are yet to see how it's been implemented, but obviously it would be interesting to have it. But a couple of years ago, I moderated a debate about whether there should be multilateral arbitration court or not. And I think there have been a lot of arguments for and against it. So it's a very complex discussion. They are yet to see how and if the EU wants to have it, because at first they were very enthusiastic about it, and then the discussions kind of went down a bit, and there have been much less talk about it. Are you familiar with mediation, Singapore Convention? Well, Singapore Convention is not as popular as New York. So basically, the question is whether the Singapore is not really popular. But the question is about enforceability of settlement agreements. There is a Singapore Convention, which is much more recent than New York Convention. It's still signed by quite a few countries. And it basically allows you, if the mediation ends up in settlement, you sign an agreement which sort of complies with the requirements of the Singapore Convention, and you can go, like with an arbitration awards, to the courts of one of the member countries and enforce it against the other side and force it to comply with it. I think it's a very good convention. It's developing. It's been signed by more and more major countries. So there is a lot of potential there, but yes, I haven't myself encountered an enforcement of a mediation agreement yet, and there isn't as much practice on this at the moment. But I think it's a very good development, and it's good to have it. So then asymmetrical arbitration. So what do we think about this? So again, I guess it's a question about asymmetrical arbitration clauses, or where one side has more options than the other. They can go to courts and arbitration, and the other side can go only to arbitration. So in that case, yeah, in most of states, again, like in England, in most of pro-arbitration countries, this arbitration clause would work. In some states, it may be a problem because the courts would view it as unequal. But in general, if you have a seat in England and Wales, it won't be a problem. US courts don't follow competence principle and rules of validity of arbitration agreements by their own. But I'm not an American lawyer, and I haven't done any US litigation on this particular issue on competence, so I probably won't be able to comment on this. US is generally, or particular state of the US, like New York, are generally viewed as very pro-arbitration jurisdictions. I don't think it's a deadly problem. Presumably, they have, in some parts of the US, they may have higher degree of review, but I would say it's not, I've never seen parties or lawyers being not recommended to go to the US courts for this particular reason. So I don't think it's a problem, but I cannot just advise on the US law because, I'm not a US lawyer. Can the UNCITRAL rules be considered superior, even if the parties have chosen another arbitral institution? Well, as I've said, UNCITRAL is not an institution. It's ad hoc arbitration rules developed by the UN, one of the committees of the UN, organizations within the UN. And they're considered to be a golden standard for ad hoc arbitration because they've been used in many cases. You can get inspiration from many cases. UNCITRAL develops different recommendations and commentaries to UNCITRAL rules. So it's easier to use them, basically. And you can, if you choose them, you can be sure that most of relevant issues will be covered by the rules, and it will be easier to navigate them. What about SIAC? Well, I mentioned Singapore Arbitration Center. So SIAC is one of the rising arbitration centers, and it's used more and more. I think in Asia, there are 3 arbitration centers, which is SIAC, HKYC in Hong Kong, which is also quite big, particularly for disputes with the Chinese angle, mainland Chinese angle. And there is also an Asian arbitration center in Kuala Lumpur, which is also popular and sort of trying to catch up with the first 2. So I think SIAC is a very good arbitration institution, and Singapore is a very pro-arbitration country. So it's also a very good option. Can we apply for different rules for different parts? As we've said, it's not recommended because you may end up having several sets of proceedings. And usually when one thing goes wrong, several things go wrong. So you may end up being forced to initiate several sets of proceedings, which is very expensive and complicated and genuinely not recommended. Yeah, and I think that's it with the questions. If you have any, feel free to add me on LinkedIn. If you have any questions, particularly like the ones about LLMs and careers, feel free to add me on LinkedIn. I may not reply fast, but I'll try to reply. And yeah, it was great to have you on this session. I think it was a very active audience. It was good to see the enthusiasm and interest in you. And yeah, good luck in your studies and arbitration career. And if you participate in the Vismut, also good luck on it. And if I'm involved in this year, it would be great to see you in Hong Kong or Vienna. Thank you so much for attending the session.
Thank you, Ivan. It was a very informative and very nice session. We appreciate your efforts, and I guess everyone enjoyed this lecture. And I think you will tell us about the possibility of sending the presentation a little bit later. Am I right? They're asking a little bit. Yes, guys, we will inform you in a separate email whether the presentation can be sent to you. But other than that, we will have the video submitted to our YouTube channel, so you will be able to rewatch them if you want to see anything else.
Thank you very much.
Thank you,
Bye.
Ivan. I hope most of the guys will have the opportunity to see you in the next Vismut seasons as an arbitrator or as the coach or as an expert. And thank you for your cooperation.
Thank you. Bye. Yeah.
Bye.
Thank you.
I would ask other participants to stay because I will send the link right now for the WhatsApp group as some of the students are facing problems with the receiving emails. And I will also send a link for the attendance for those students who joined a little bit later. But just a second, please. So before